question 4 from July of 2024. It turns out to be a civil procedure question, and it's California civil procedure. How do we know? Because it ends up in a California Superior Court. Now, they don't say answer according to California law, and believe it or not, the selected answers pretty much don't even go into any California law. So it goes my theory, just really understand how the concepts work. Let's take a look. Call number 1. Did the court err in seating juror number 5? So juror number 5, should they have been on the veneer? Number 2, did the court correctly deny Pam's motion for a directed verdict? And a directed verdict in California is the same thing as a motion as a matter of law, which is made after the opposing party has presented their case during trial. Now, it's interesting because the 7th Amendment has not been selectively incorporated into the states, meaning that in federal court, you have to make a motion for a matter of law during trial to renew it after trial. No such requirement in California. Now, the question doesn't go into that. One of the selected answers does discuss that, and I believe improperly too, which surprised the heck out of me that they misquoted it. Number 3, how should the court rule on Pam's motion for a new trial? New trial. Say from the top. A car manufactured by Motor was in an accident. Palma was in the front seat, passenger seat, during the accident when her seat collapsed, resulting in serious injuries. So I'm picturing it. I guess the seat must have went all the way back or something happened to it. She properly filed and served a complaint in California Superior Court. So you don't apply federal law unless you're literally suing on a federal claim, then you'd apply that substantive law. When you're in state court, you apply state procedural law and any kind of state substantive law for negligence, so California law and negligence. So she sued the manufacturer Motor, asserting defective seat design. So this is actually a strict products liability case for defective designs. And for anyone that remembers torts with design defects, it really is a balancing test. So a design defect is a negligence analysis in disguise. The magnitude of the harm, the likelihood of the harm, the cost that it is for the manufacturer to replace things. For example, seatbelts, airbags, cameras, when you're reversing, like the cost is slight compared to the likelihood that you're going to hit somebody when you reverse and the magnitude of harm that's going to cause. And it's not going to kill the utility of the car because the camera makes everything actually better, which is why you'll see new model cars have cameras in it because it's now cheaper. 20 years ago, it wasn't like that. It was very expensive to put a camera anyway. Okay. So the first paragraph really does just the setup of what's going on. And you'll notice the second paragraph goes to call 1. Third paragraph goes to call 2. And the last paragraph goes to call 3. This is a very common pattern on the exam where they have each paragraph going to a separate call to question. This one goes right in order. So during jury selection, juror number 5 revealed that she had worked as a motor engineer before retiring 5 years ago. Okay, well, they don't use things like 5 years ago, 2 years ago, 1 week later, 2 weeks after, unless they're getting at something. The fact that they retired 5 years ago, and I thought it was really brilliant the way one of the selected answers discussed this, was did they work on, they're an engineer. The juror number 5, she was an engineer and she's now retired. So I'm thinking to myself, and so the selected answer so brilliantly it did, she probably worked maybe at that company for 30 years. We don't know if she's been in other places, but let's maybe assume that she's been at Motor for 30 years. She's got allegiance, she's got loyalty to them, she's got friends there. She probably knows people that worked on the design of the seat. And right there, that's going to create a tremendous amount of bias. I mean, if I worked for a company, as long as I left on good terms and she retired there, I'm assuming it's good terms, pensions and whatnot, that's a significant factor in indicating bias, which is the entire discussion of what is going on in call number 1. And ironically, it's not. It's a really simple discussion, but there were really creative arguments made by both selected answers. A lot of the times, people are so overly consumed with memorizing words instead of just having a dialogue with the grader. Hey, this is what's going on. And everything that I'm discussing here, notice the last word on every single California bar exam essay is discuss. What am I doing now with you? I'm discussing this fact pattern. I'm explaining like, whoa, 5 years ago, did you work for the company? These are all things that you would put in your analysis. And it's not about the rule. Notice how select an answer A and B, they really don't even go into a rule statement here. Because what's the rule? Okay, if you're biased, they should be removed for cause. Simple as that. And if the court doesn't remove them for cause, and they should have, well, then in criminal procedure, this actually gets tested on the MB law, that if the juror is on the veneer, and you get convicted, the defendant gets convicted, they have to overturn the verdict. And of course, there's that one case where the defendant used a peremptory challenge to get rid of someone who should have been removed for cause. And so they never did serve on the veneer. The defendant got convicted, and the appellate court's like, hey, no harm, no foul. They weren't there, so you didn't have a biased juror. You only lost a peremptory challenge, which was not a constitutional violation, no reason to overturn the verdict. Anyways, here, we have a biased juror because of the fact that they've been working there. So, previous employment. And allegiance to them. Did they work on it? Did they design? Did they help design this seat? We don't know exactly what juror number 5, what her responsibility was. Now, she might have retired before this. I mean, I don't know how often car manufacturers redesign seats, but I would assume that, I don't know if technology really advances to the point where the seats are going to be changed. So it's possible that she may or may not have, based on the 5 years, or she knows anyone who did. She also disclosed that she still owns 50 shares of motor stock, which amounts to 2% of her total financial assets. Engineer, 30 years of the company, I'm assuming. I mean, she's retired now, probably built some wealth. What would he 2%? Let's just say she's a millionaire. I think that's reasonable to assume somebody who's an engineer. Engineers get paid well. So 2% of $1 million would be about what? Was that 20,000? Is that right? So about 20,000. Is that significant? No, I mean, even if you lose half the stock, it's only 10 grand of $1 million. It's not a lot. So the 2%, so we have previous employment, which is bias, loyalty to company, or potential loyalty to company, nothing is set in stone. They make it really gray, and financial interest. But, some of you might own Apple stock or Microsoft or NVIDIA or whatever the case is. It doesn't really make you biased for Microsoft. A lot of people that own shares in publicly traded companies aren't necessarily, you're not Warren Buffett here. You're not like your biggest holding is Apple, even though he just sold off 150 million. Love Warren Buffett, love Charlie Munger too, who just passed away. So financial interest is a reason. I don't know if in this case it's a significant enough reason for them to be removed. So Palma challenged the seating of juror for cause. And when you make a challenge for cause, the court has to decide whether or not they are going to be biased. And now the fact that juror number 5, and the court denied it because juror number 5 said she could be fair and impartial. That's not an indicative factor. Oh yeah, I'm sure I can be fair and impartial. We all think we're objective. We all think we're open-minded. In reality, are we? I mean, no, you believe what you believe. And even in the face of some contradictory evidence, people aren't going to change their opinion. So the fact that you just say it, so saying she could be objective, well, sure, she may think that, and she may honestly think she could be objective. So we have bias, the previous employment, possible loyalty to the company. Did she work on it? Did she work on the seat? And for those of you that have checklists or templates or flashcards, tell me if any of this is on it. The answer is no, because these are not rules of law. These are not canned statements. These are not buzzwords or headings. It is an actual factual discussion that they were looking at in call number 1. And ironically, that was the most important call. Now, granted by not too much, I would probably say like maybe 35%. Probably 25%, something like that. If I was going to do the math, what would be the remainder? So whatever, 35, maybe 30. So, okay, approximately, I'm just approximating. I haven't really done the numbers yet. I haven't really looked at the word count and done a model answer yet. Okay, so did she work for did she work on the seat? Was previously employed? How long was she there? Allegiance to the company. You might have friends who worked on it, so she'll not want to throw them under the bus. And possibly open up motor to potential other litigation, class actions, recalls. That's really expensive. Financial interest is pretty de minimis. and the fact that she can be objective. I think these are the two least important factors, where the bias and everything else are probably the most important factors. And that's call one in a nutshell. That's call one. Number two, so we're going to the paragraph that starts, during trial, Motor presented evidence that the seat was not defective and that any injuries that Pam suffered were due to reclining the seat to an unsafe angle. So they were saying that she's comparative negligent. All right. Well, Pam could still recover even if she was at fault. You can use comparative negligence in strict liability cases for those of you that aren't aware of that. So let's just say she was 40% at fault. She gets 60% of her damages. Pam submitted evidence that at the time of the accident, a bookshelf was in the back seat, which prevented excess reclining. Now, if you do have a bookshelf back there, we have all had stuff in the back seat, or you've had someone in your, if you have a sedan or something like that, somebody who's got their legs there, you can't back up, it's kind of like you're on a plane with a kid kicking your seat. So you know that, okay, certain times you can't recline it all the way. All right. They're saying it was an unsafe angle. She's like, well, that can't be the fact. That can't be true because I had a bookshelf there, so my seat was kind of upright. Well, this is the jury's responsibility. Don't forget, directed verdicts, they're motions that are granted as a matter of law, meaning taking everything you say is true, you still can't win. And that's why they say in the evidence viewed in light of the non-moving party, it's viewed favorable to the non-moving party. Another way of saying that we're gonna, and I just forgot what it said, taking everything you say is true, is there any chance that you would lose? And if so, the court's going to grant it as a matter of law, because hey, we're going to grant you everything you said is true. And if you still can't win, then we're going to get the motion. Because like as the defendant, I'm going to say, Palma is saying that's why they say the evidence in favor of the non-moving party. Here, it's Pamela moved for directed verdict. So she's saying that everything that Motor said, we're going to take at face value that everything Motor said was true. Okay. And Motor still can't win. That's not the case. That's why the court should have denied the motion, which they properly denied the motion. Okay. So at the close of evidence, Palma moved for directed verdict, arguing that misusing a product is not a defense to a design defect when the misuse is foreseeable. Okay. Yes, that is something that manufacturers have to guard against, any kind of foreseeable misuse. Like, for example, guns have safeties on them. You'll see ladders have certain hatches, or a lot of things that get misused. I mean, most chairs, even before class, Moses was on the chair taking down the blinds. I mean, that's a foreseeable misuse, people standing on chairs to reach something from a high level. So the court denied Pam's motion and a jury verdict was issued in favor of murder. So notice that she made the motion at the close of evidence, comma. All motions for directed verdict, they can only be made after the opposing party has presented their case. So the plaintiff goes first, plaintiff has the case in chief. After the plaintiff's case rests, the defendant can now move for directed verdict. The plaintiff cannot move for directed verdict at the point. So the defendant's going to be the first one to move for a directed verdict because the plaintiff goes first. All right, so the plaintiff presents their evidence. Now, when the defendant puts on their case in chief in rebuttal, after that, which is pretty much at the close of evidence, that's when the plaintiff can move forward. And as you notice, Pam moved for it at the close of the evidence, which means obviously Motor presented their case because we even have it, they presented it at trial. So the timing was fine. And it's a really simple rule of law, looking all evidence in light most favorable to the non-moving party should the court grant it. But realize this is a complete factual, credible discussion. Situation where the jurors have to determine who's telling the truth. Did she really have a bookcase there? Could the seat really have been reclined? Did she really recline it too much? Is what Motor's saying true? The jury has to weigh the evidence and assess credibility. That's why the motion should absolutely, unequivocally have been denied. I don't think you can make any reasonable argument that says the court should have granted the motion. There's just no way, because the jury assesses credibility and weighs the evidence. There you go. So we have the timing issue. And the foreseeability issue is a question of fact. So whether or not something is foreseeable, whether misuse is foreseeable, That's again, it's not a question of law. Whether somebody is owed a duty is a question of law. The judge says when you're talking about negligence, whether somebody owes you a duty of care, that is a question of law. What's foreseeable is a matter of fact. So, except for them, we have to know how far back was the seat, and because there's competing evidence that have been presented at trial, the motion is unwarranted. So the jury must decide if the seat was too far back, and they don't know who to believe. Okay, so again, not a very difficult question for call number 2. Call number 3, the new trial. It says 2 weeks after the jury verdict and judgment. So 2 weeks later. Notice they say 2 weeks. That lets you know that the motion probably was timely. Now I noticed that the selected answers, one of them quotes federal law, which under federal law, post-trial motions are 28 days. However, we're in a California state court, so you have to apply California law, which neither does. And I'm really surprised that selected answer B said 30 days. Well, 30 days is the time for an appeal. And under California law, from what I understand, it's 15 days. Better be right about it. So if that's the case, then none of the selected answers picked up on that, and her timing, her motion would be actually late because it was 3 weeks late. However, again, the examiners don't make a big deal about this. They just let it slide. And one of the ways that I explain to students, instead of worrying and bogging yourself down with the minutia of California law, because it's so infrequently tested, obviously outside of community property wills, because that's all you need to know is California law. But even with PR, just know the main rule. Just understand what, new trial motions, it has to be timely. And why can you make a new trial motion? About newly discovered evidence. Okay, so let's take a look at the last paragraph. 2 weeks after the jury verdict and judgment, so it's been entered, Pamela received anonymous reports of motor safeties tests conducted 3 years earlier. Now, these reports are 3 years old, but it's interesting because don't forget, juror number 5 retired 5 years ago. So now it makes it even more likely that juror number 5 probably worked on this or probably knows somebody who worked on it. I mean, it's a big company. They could have been completely far away from what's going on with the seat design. But I'm saying it makes it more likely now, because if this is 3 years earlier, that means the seat was probably designed 4 to 5, maybe 6 years ago. Who knows? Just just connecting dots to get a discussion. And this is what the selected answers do so brilliantly that a lot of people don't do, is that type of discussion where they really understand the intricacies of the fact pattern and paint the picture. You can see them painting the picture and really understanding exactly what's going on. Because an attorney, when you go up in front of the jury and you have to be able to bridge those facts together. Because if I was Palma's attorney, and I'm talking about juror number 5, look, they were there 5 years ago. We have reports from 3 years ago, assuming they had the reports, that they knew the seat was defective, which makes it even more likely that they knew somebody was working on the seat. They had lunch with someone who's on the seat that worked on the seat. They could have helped design it, and they're not going to impeach their own work. So, it's just a discussion. So newly discovered evidence. Now, the thing about newly discovered evidence is it can't be a new scientific breakthrough that happens after the trial's over. Right? So the evidence had it been discoverable during trial, but for some reason you had no access to it. So, and the reason why that is because think about this, it would open up every single verdict in the past, because things that were decided in the past, now, if you look at the way technology advances, it would completely change the outcome of something that happened years ago. So that's why the evidence had to be available during the trial, but for some reason you couldn't get access to it, or you couldn't find it, or there was no way. So the report showed that severe injuries were likely regardless of the angle of the seat. Oh, so that completely discredits this entire argument by motive. Like, hey, she misused it. It didn't matter whether or not she was using it properly or not, because according to your own reports, you are going to get injured during an accident, no matter how you had the seat, up, back, it didn't matter. So that's really strong evidence. 1 week after receiving the report, which means it was 3 weeks later, and that's after the 15 days. Monica, do you remember the statute number for that, please? 659?
In California, the clerk always mails you a notice of entry of judgment. So it's either 15 days from the notice of entry of judgment.
Okay, when you receive the notice.
Exactly.
Yeah, okay, that makes
If you
sense.
don't get notice, then it's 180 days. Almost never.
Yeah, if you don't get the notice, it's 180 days. That's correct. Okay, that's what I remember researching. So I think it probably was timely. Because like when it mails out, what's it gonna get it 2-3 days later? And she makes, she did it 3 weeks later instead of 15 days. It's gonna be really close. But for those of you that want to look it up, it's California Code of Civil Procedure. I don't know why I put that. California Code of Civil Procedure. 659. Okay, so when we got PAMA filed a motion for a new trial, I would argue that it was timely, arguing that the verdict was flawed. And the verdict is flawed for 2 reasons. We'll get to those. And produced evidence that Motor had intentionally hidden the reports. So here's the 2 reasons why it's flawed. Most people didn't catch the second reason. A lot of people are like, oh yeah, like the fraud on the, well, it's not really fraud on the court, but the misrepresentation, the newly discovered evidence. Okay. But one of the main reasons, the easy reason why this verdict was flawed, anybody catch it? It's because the biased juror was on the veneer. So you have a flawed verdict from the outset, and guess what? Motor wins. Motor won the case because the jury verdict was issued in favor of Motor. And if they had this evidence, and if you didn't have a bias, even if they had this evidence, there's no way Motor wins. They settle class action. But if they don't have this evidence, there's still a chance that Palma might have won if we had an unbiased juror. I mean, I don't know if it has to be unanimous in California. I don't think it does. Federal courts, it does, but California, I believe it doesn't. So who knows what the vote was? It'd be different if it was 6-5 or something like that. Okay, so there you go. This essay boils down to really a discussion of the facts. And that's it. Not a lot of law in it. And that's a recap for the question 4, July 2024.